Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3052. United States of America versus Terrell Armstead, known as REL, also known as Supreme 16. Mr. Zucker for the appellant, Mr. Hobel for the appellee.
Morning, Jonathan Zucker and Patty Dawes on behalf of the appellant for 5 minutes for rebuttal. There's two issues before the court on this brief, and they both relate to jury issues. The first is the dismissal of one juror, and I suggest Brown is the controlling precedent here. The juror expressed concern and during that, requested to be dismissed from the deliberations. And her reason was that she was uncomfortable with, as she put it, that my answer, and I'm uncomfortable with the backlash or the backfall of it. It was pretty clear in this context, her answer was synonymous with verdict. The court intuitively or implicitly acknowledged that there was a severe possibility or significant possibility that she may have been the holdout, as later facts established she really was. And because her decision to be excused from the juror and the judge's decision to dismiss her could not rule out the possibility that it was based on the evidence and based on her verdict, under Brown, it was error. That's very
Doesn't
simple.
Brown stand for the proposition that the court can't excuse a juror based on her request that stems from her view of the evidence? But in this case, she was excused because of a lack of candor during voir dire, which is separate and apart from her views of the evidence, is it not?
If that was the sole basis, did the court have discretion to dismiss her based on a lack of candor during voir dire? Yes, the court would have had that. But the problem in this case is there's the significant possibility that her request was based on her different view of the evidence from the rest of the jurors. And under Brown, given the fact that it has to be transparent, if the Brown court found that if there's the possibility that it has to do with her view of the evidence, then that should not be permitted. Now,
did the court focus on the district court's reasons for excusing her, not what her request focused on?
Well, and that's fine, but the district court was not clear. The district court said, I can't look into her mind and tell whether or not she was intentionally deceptive during the voir dire. And the district court also found he could not say with certainty that it wasn't because she had a different view of the evidence. As the district court conceded, it could be that she's a holdout and that did her experience with her father possibly affect her evaluation of the evidence? Well, that's possible, but that's not a basis. If it had been a transparent thing, if the court had made a finding that the sole basis for her coming forward is her failure to disclose previously the conviction of her father on a related offense some nearly 50 years earlier, then yes, I would agree with you. But it's that it was intermixed with her view of the evidence that made it impermissible. And I'm repeating myself. Go ahead.
I understand. But go ahead.
But the misconduct has nothing to do with the juror's view of the evidence.
Well,
the basis for the exclusion was lack of candor with the court, which, on this record sounds like a charitable characterization of.
I would tend to say it's not that clear on this court, and the court did.
You didn't remember that her father was convicted of the
prostitution when she was 6 or 7? A father who died when she was 10? How much? I'm assuming that once he was convicted, she had no contact because he was incarcerated. So how much contact did they have, and how present was it in her state of mind when she was answering voir dire questions? Actually, the voir dire, I was the one who asked her about, not knowing anyone on who'd been convicted of a crime. And so was it an innocent misrecollection or was it an intentional falsehood? The judge even acknowledged he couldn't make that call definitively. He said, I can't look into her mind and make that call. And if you can't make that call, that it's an intentional falsehood.
Is lack of candor. All right, so
But
if we spot you the difference between intentional misleading and just lack of candor, I take those points, but is lack of candor an independent ground adequate to support excluding?
well, I think in that instance, the court has to do a test to say, was it intentional or not? And how did it affect, does it prejudice the proceedings at all? So if for the sake of argument, there's lack of candor, but it wasn't intentional, it had just not come to the forefront in her mind because it was something that happened 50 years ago when she was 6. I would say that in and of itself wouldn't be a basis to dismiss. But overlaying everything in this case is the possibility that it had to do with her view of the evidence, that she was coming forward because of her view of the evidence. And that was the reason this decision violated Brown. Now,
Counsel, I think that just goes back to the first question, which is why should we be focusing on why she came forward as opposed to why the district court discharged her? And if we think it's incredibly clear that the district court discharged this juror because of misconduct in voir dire, I think our cases say it's entirely irrelevant whether he also knew she had doubts about the government's evidence. Isn't that right?
I would disagree, because if at the time it comes to the forefront, there is the possibility that she has a different view of the evidence. And as the trial judge correctly or intuited, she was the holdout. And so because her decision to seek removal was colored by that possibility, and the judge looking at the case was bound to say, no, if it's based on the possibility that it's her view of the evidence, then that's not a basis to dismiss a juror. I mean, the case law is pretty clear on that. It has to be transparent.
Suppose a juror in the middle of deliberations posts on social media a screed about how outrageous the prosecution is, right? So very clear misconduct, very clear indication of the juror's views. District court couldn't dismiss that juror based on the misconduct?
I think they probably have to, because they violated the oath they took to not communicate on social media, and they'd already formulated an opinion before the close of the evidence. So, but that's not the situation we have here. So with all due respect, I'm not sure how it's apples and oranges.
Why isn't it? If the dismissal rests on the lack of candor, as opposed to whatever the court might have known about the juror's possible views, it's exactly the same.
Well, it's the same in that the juror is making a declaration about their views. But in this instance, I mean, that's such a blatant violation of the rule about not communicating with somebody outside of the jury that I think that would be the basis for their dismissal. I mean, I frankly have to think of it in terms of, well, is that tainted because the dismissal is in part, not in part, but it indicates, I mean, the dismissal is because of the posting on social media. It's not because of their view of the evidence in what you said. It's much more transparent. It's much more transparent. Where in this case, coming forward was, as the court acknowledged, possibly, and then the dismissal was sought possibly based on her different view of the evidence and her being a holdout. I'm running out of time.
You want to move on to question
Sure.
2, unless my
Sure. Well,
colleagues have other questions?
Sure. Question 2 is the rule says what the rule says. When you have a deliberating jury and you have a juror who could no longer continue, you have 3 options: mistrial, go with 11, or bring back an alternate. In this case, the jury was already down to 11, so you couldn't do that. And you couldn't bring back an alternate because the court had already found when the first juror was excused that bringing back an alternate was unrealistic because of the amount of time they'd gone with deliberations. And so the only option left to the court under Rule 23 was to declare a mistrial. It was not to say to the jury, well, we're at the point where we're going to have to dismiss you because of COVID, anyway, would you like to render a partial verdict? I mean, the invitation, it interfered with and infected the jurors' ability to deliberate. This was not a situation where the jurors had indicated at all, at any time, that there was a deadlock or an impasse, and something which would have warranted an invitation to, or a re-instruction that you could render a partial verdict.
Isn't this, though, analogous to a situation where there is a deadlock and the court takes a partial verdict? Because the alternative in both cases is a mistrial. And a mistrial is something that we've said in our case law we should avoid if we can. It's very costly to the system and to the parties to declare a mistrial. And so here, the option was declare the mistrial or first ask, and I think the judge was very careful not to be coercive about this, but to ask whether you've reached a verdict. And if you have, let us know what it is. It seems to me very much on fours with a deadlock situation, because what we're trying to avoid is a mistrial.
I mean, clearly the judge was trying to avoid a mistrial that was going to have to be declared because of extenuating circumstances related to COVID. I would agree he did everything he could to be uncoercive in his instruction. However, the case law is pretty clear. Unless a jury indicates that they're deadlocked or at an impasse, inviting them to render a partial verdict is tantamount to...
I don't know if the case law is clear, because this is a sort of unprecedented set of facts. And so normally a court is faced with a deadlock and you can just declare the mistrial or ask for the partial verdict.
Right.
Here, the district court was forced to declare a mistrial, but before doing so, he just asked for the partial verdict. I just think that's very analogous to a deadlock situation.
Well, it's analogous, except it doesn't have the deadlock, which is what warrants the giving of the partial verdict. In this case law,
the mistrial, I think, is the thing that is, the mistrial is the thing that is so costly to the system, because then you have to have another trial. There were 4.5 days of deliberation. And
right. And it was a
7-day trial. It's a big cost to the system. So before we go down that road, if it's not coercive, why is it erroneous or an abuse of discretion to ask the jury in a non-coercive way if they've reached a verdict on one of these counts? There were multiple counts.
I'm not saying it wasn't a reasonable decision on the court's part. What I'm saying is that the case law talks about it's error for the court to invite a partial verdict absent declaration of deadlock. And here, this jury had never indicated that they were deadlocked. That they were an impasse.
That stands for that proposition, that there must be a deadlock or else there cannot be a partial verdict.
Probably Lavelle, or my recollection off the top of my head, either Lavelle or Moore were the two on that point.
Thank you.
All right.
What source of law are you invoking for this?
I'm sorry, I didn't...
What source of law are we talking about? The Sixth Amendment? Are we talking about Criminal Rule 31, or are we just talking about this court's supervisory power over tribunals inferior to us?
I think it's Rule 23 sets out what the court has to do.
31?
No, 23 is the one that talks about, when a jury, the three options open to a court when they're in a situation like this where they can't, what triggers it, where they no longer have a full jury. And Rule 23.
Counsel, your briefs argue this should be subject to the constitutional harmlessness standard. And
right.
They clearly argue it's a Sixth Amendment right. And that's how it's portrayed by cases like Lavelle and others that you rely on.
That's on the second issue.
So, correct.
Right.
I think that was the question. The source of law for your second issue.
I think what you're trying to get at is the harmless error issue. And I think in this context, the defendant was denied the right to have the jury fully deliberate and come to a verdict on its own. And that's what comes forward in Lavelle and Moore, that you can't infringe upon the jury's.
I mean, here's how I'm thinking of it. If we're talking about the Sixth Amendment, there's very spare text, and we would have to look at history the way Ramos did, right? Jury verdict means unanimous verdict. You know that from hundreds of years of practice. Maybe there's some analogous principle that jury verdict means a verdict structured however the jury wants to structure it, but I don't see that. Well, I mean, it seems to me we're just talking about our court's supervisory authority, judge-made law to make sure that trials don't run off the rails. And if that's what we're talking about, I would think we give the district court a fair amount of leeway to deal with weird circumstances as they come up, like an emerging pandemic.
Undoubtedly, that was a significant factor in the judge's decision-making, that everything was being shut down. And I suspect throughout this country, on the day the courts were shut down the courts were shut down because of the pandemic, there were probably lots of trials that were going on, and probably, I would assume, lots of juries that had not reached finality in their verdicts. And in that situation, a mistrial should have been declared.
So the district court has this hugely exigent circumstance, deals with it as best he can. I agree with Judge Pan, the instruction was not coercive. So what's the harm to your client?
The harm was that the jury was not allowed to complete their job. That they were invited to, it was an invitation to render a verdict when the jury had not indicated that they had completed their deliberations. And the fact that they had preliminarily indicated they may have reached a verdict on one count, but then chose not to give it that day, the court does not have the option to say to the jury, we're about to declare an abatement of the proceedings. I wouldn't have used the word mistrial. Can you render a verdict? And in essence, that's what occurred here. Now, I agree that Judge Mehta did everything he could to be as uncoercive as possible, but it is the giving of, as other case law have said, when the judge invites a partial verdict, absent a indication from the jury that they are at an impasse, it's improper and it's error.
It's concerning if there's reason to think that the jury is either tricked or feels coerced into handing in something as final that the jury thinks is tentative. That didn't happen here.
Well, we don't know whether or not it happened here. And as the case law points out,
the juror told the court, we have a verdict on one count.
They did, but then they chose, and they did not render that verdict. They were continuing to deliberate. And the case law makes clear that the jurors may have a tentative view on one issue, and that view may change, and it's up to the jury to control their deliberations as they see fit. And in this case, that was infringed upon. Now, while there's sympathetic circumstances, yeah, of course.
I think when Judge Mehta asked the jury, if the jury foreperson, I guess, whether they had reached a unanimous verdict, there was no objection by you. And
I actually wasn't there, but
by the defendant. And then there were only 20 minutes left in the day. So
That's right.
The fact that they didn't come back with a verdict does not seem as significant, given that they didn't really perhaps have time to do so before all of these other events happened that made things go off the rails.
Whether or not they had enough time to do so is a judgment call. But what clearly prompted the giving of the partial verdict was the instruction when they came back that Monday, and when one of the jurors had to be excused, period.
But then you're asking Judge Mehta, who has been told that there is a partial verdict, to just not ask for it. Because under the particular facts of this case, with no objection, it was elicited from a member of the jury that there was a partial verdict. And then these exigent circumstances happened where the deliberations would have to end due to the pandemic. The district court knew that there was a partial verdict, or at least one juror had indicated so. And you're saying that the proper course would be just not to ask them for it and take a mistrial, which is very costly.
Under Rule 23, that is correct. Yes, that the court should not invite a partial verdict absent a declaration from the jury that they are at an impasse or that they wish to bring a partial verdict. I mean, at the point this was all happening, one juror wasn't even was participating by Zoom or something. They weren't even all present.
Well, they weren't deliberating. They were just supposed to elect another foreperson and then fill out the sheet.
Well, but they had not declared their deliberations at an end. They were still deliberating, and then they were told by the judge, essentially give us your partial verdict. And with all due respect to Judge Mader, who was, balancing all the equities he could, under the case law, that was error.
Okay, thank you. We'll give you some time on rebuttal.
Appreciate it.
Morning.
Good morning, Your Honors. May it please the court, Mark Hobel for the United States. This is a case about discretion, reasonable exercise of discretion. I don't want to take my colleague out of context, but I think I heard him say that with respect to the verdict, I'm not saying it wasn't reasonable on the district court's part. The district court did. The court's instruction, it's allowing the foreperson, juror 13, to complete 2 limited tasks that morning, deliver any unanimous verdicts that the jury had, was not an abuse of discretion. I think that some of the court's questions to Mr. Zucker illuminated there isn't some clear legal prohibition or clear legal precedent that guided the court's decision-making on Monday morning with the impending pandemic.
Well, Mr. Hobel, I think that's true in this circuit, but for example, the 10th Circuit's LaValle, I'm not sure how to pronounce it, decision, do you think there's any distinction from that case and this one?
I think there is certainly some similarity in the sense that the district court in that case gave a similar instruction that said if you have any unanimous verdicts, you can deliver them now. And of course, the 10th Circuit said that was error. Now there's some, I think.
Well, just to be precise about the error, right? The court says, just like the 10th Circuit, 8th Circuit, 7th Circuit, 5th Circuit, by my count, have all said that you can remind the jury of their ability to return a partial verdict. But the line is crossed if you cut off deliberations and require them to deliver any partial verdicts that they have. I think that's the setup in all 4 of those cases. And I don't think there's a case that has come out the other way on similar facts. Are you aware of one?
I did. Yes, I disagree with that there's some unanimity here. We cited in our brief the Harriet case from the 6th Circuit and also from the 10th Circuit. I believe it was the McKinney case, which predated LaValle. And in both of those cases, the judges said, look, if you have any unanimous verdicts, you should deliver them at this set time, or you should, I may be mistaking the mechanics of this between LaValle and McKinney in terms of who said seal them in envelopes, but in both of those cases, you had district courts indicating if you have, like the district court did here, if you have any unanimous verdicts, you can deliver them now, should deliver them now. But if you're not unanimous, bending over backwards, and I'm taking that language from the Patterson case, which is a 10th Circuit case that postdates LaValle, bending over backwards to make it clear there was an option, that it was not meant to convert a tentative verdict into a permanent. That's what we have here. And even in LaValle, the court found it was harmless, even under the Chapman standard for harmless error. The court found, the 10th Circuit found harmless beyond a reasonable doubt because it was non-coercive. And there's no argument here that this was coercive.
I think that might be right as to whether it was coercive at the time. But the thing that the 10th Circuit, so McKinney, yes, was 1975. The LaValle case, I think, is 2006. So, and I think the Harriet case, is essentially an invited error case. But just put aside sort of counting up the cases. What the 10th and 7th circuits have essentially said is, yes, this is a formal rule, but part of the right to a trial by a jury is to have the jury structure its deliberations, including deciding whether and when to deliver a partial verdict. Now, I think we would have to disagree with those statements to rule for the government in this case. And I'm just, the question I had is, why is that articulation of the jury right incorrect?
Well, there's a few, and I hope you'll give me an opportunity to unpack that. One, not that it matters. I believe McKinney was 1987. It's a little more recent, but still somewhat dated. Number two, as to the 7th Circuit case law, I think Your Honor is referring to Peake and to Moore. In both of those cases, you had the judge giving a fairly standard partial verdict instruction hours after the jury had begun deliberating. I think in Peake, it was like at 3 a.m. On a early morning Saturday. Not sure how you're allowed to do that, but apparently they were. So in this circumstance here, you had the jury that was out for 4.5 days. That's roughly half the time that this trial took. They were out for a long time. And in terms of the indication, you can't just tell them to give a partial verdict. I think if we parse and we're careful, and the district court was very careful in how it gave this instruction, it wasn't said, give me any verdicts now. It said, if you have any, you should deliver them now. If you don't, just write no verdict. And they came back and they said no verdict on 7 out of 8 counts, which is entirely consistent with what the foreperson said, where the foreperson said they were on Friday at the end of the day.
Can I ask a question about these other cases from other jurisdictions? It seems to me that when a jury is mid-deliberations and you force them to give a partial verdict, that is one situation where the verdict could change because the jury's going to continue deliberating, and there could be changes of heart, or there could be horse trading or compromises that could cause something that was a preliminary verdict to change. But in this situation, we know that the deliberations are ending. The jury doesn't know it, but the district court knew that was the case. And it seems to me that there wasn't going to be an opportunity for continued deliberations where verdicts could change and there could be reassessment of a prior verdict made. And I'm wondering if that is a fact that distinguishes this case from some of these cases from other jurisdictions.
It is absolutely a fact that distinguishes this case from other cases. I think it was a material fact in those cases. I think more is coming to mind here, that the jury continued deliberating and returned somewhat inconsistent verdicts or didn't. I think there was one of either Moore or Benedict in which the partial verdict instruction was given. The jury returned a guilty verdict on the 924C count and then continued deliberating, and it either acquitted or had a mistrial on the underlying predicate.
So it seems that there was no room for the jury to structure its deliberations any further in this particular case, which distinguishes it from those other cases.
That's entirely correct. That's entirely correct. And it is true. There were additional safeguards in place here. The district court said, I just want to make sure I'm quoting from it's the record here. It said, none of this is meant to, I'm not asking you to come to a conclusion if you have not, and then he again warned the jury, none of this is meant to urge you or to compel you to reach a verdict as to any particular count. It also didn't say your deliberations are going to continue. It said, come back after you've completed these 2 tasks and we'll sort of reassess from there. So it didn't squarely say that deliberations were at an end, but it also didn't say that they were going to continue. Just to briefly respond to the Rule 23 unavailability point, this is not a situation. This is absolutely not a situation where the clear text of Rule 23 proscribes what the district did here. The district court never found that the juror was unavailable. It found she could participate remotely in completing the two limited tasks that it assigned to the jury. One, a largely clerical one, picking a new foreperson. Two, completing the verdict form with any unanimous verdicts they had reached at that point in time, and writing no verdict next to any counts where they had not reached a verdict. So this isn't a situation where Rule 23 clearly governs and describes this, and therefore this is an area that's committed to the district court's discretion, and it reasonably exercised its discretion. It weighed, I think that to quote it, the district court, it weighed the things it had to weigh in the balance. That's what we ask district courts to do. It appropriately exercise its discretion here, because a mistrial is very costly and really is to be avoided whenever possible. That's what the district court did here. Unless there are any further questions on the verdict, I'm happy to turn briefly to Juror 10. Okay, so there was an independent good cause justification for removing Juror 10 based on her jury misconduct, namely her lack of candor during voir dire. That was unconnected to her view of the evidence. She hadn't heard any evidence at the time that she was asked at least 5 times, and Mr. Zucker is right. He asked her at least 3 of those times, incredulously. Really, you don't know anybody who's been convicted of a crime in your 53 years of living in DC? I think the district court was somewhat charitable, Judge Katsas, in how it characterized Juror 10's conduct here. I think but certainly at a minimum, it found there was a lack of candor. That is sufficient to remove her. It provides a sufficient independent good cause justification. Therefore, there was no abuse of discretion. Just very quickly before I sit down to correct the record here. The district court did not find that Juror 10 was a holdout. It very explicitly found, I'm not saying one way or another. It said, and I'm just quoting from pages 57 through 58 of the supplemental appendix, the court found, I'm not taking from her statements any certainty one way or another as to whether she is a holdout or that she is on board with the government's proof and is just simply having a difficult time given her past with all of it. So, again, there's no finding there that the district court explicitly didn't go down that route. The district court properly focused on her misconduct during voir dire.
Just very briefly, though, isn't the rule, if it were absolutely clear she was the holdout, and it was also absolutely clear she lied during voir dire, you would say, if the judge says solely because she lied during voir dire, I'm discharging her, that's okay, right?
Absolutely. I 100% agree with that. I'm just in terms of correcting. Unless there are any further questions, we'd ask that you affirm judgment of the district.
Thank you very much. Mr. Zucker, we'll give you 2 minutes.
Regarding Harriet, the distinction in Harriet is that the jury twice, I think, came back with notes saying they were at an impasse. And that takes it out of the realm of what happened here. And the only other point is that I believe when the court made the ruling it took away the jurors' right to reconsider and change their mind prior to rendering a verdict, which is, I would suggest, an intrusion. And the third is the judge never made an independent finding clearly establishing what the basis for striking the juror was, that it was based on lack of candor versus her inability to deliberate because of her view of the evidence. Had he made that finding, we would be in a different stead. He purposely curtailed his inquiry so as not to tread into those areas, and because of that, he never made the findings. That's all I've had in response. To any other questions?
Thank you. Mr. Zucker, you were appointed by the court to represent the appellant in this case, and we thank you for your able assistance. The case is submitted.
Case number 22-1251. Public Citizen Inc. petitioner versus Federal Energy Regulatory Commission. Mr. Joshi for the petitioner, Mr. Glover for the respondent, Ms. Key for the intervener.
Joshi, good morning.
Good morning. May it please the court. This case challenges a pair of orders from the Federal Energy Regulatory Commission in which the commission concluded that it does not have jurisdiction over export facilities that deliver liquefied natural gas to ships by truck. That decision was wrong. Congress gave the commission exclusive jurisdiction over all natural gas export facilities, quote, located onshore or in state waters. The only export facilities excluded from the commission's jurisdiction are deep water ports, which Congress expressly carved out from the scope of the Natural Gas Act. In the commission's view, however, onshore in the Natural Gas Act does not mean on land, the way it does in every other oil and gas statute. But if onshore doesn't mean on land, the commission never coherently explains what else it could mean. It cannot mean near the coast because even the commission agrees that it would be arbitrary to regulate export facilities differently based on their distance from the coastline. But the statutory text allows for no other options. It must mean on land. What the commission has done instead is to say that onshore doesn't refer to a facility's physical location at all, but to the way gas is transferred from to ships for export. If by pipeline, the facilities are onshore. If by truck, they are inland facilities that fall under the state's authority. Congress, however, did not write the statute that way, and this court should not read it that way. Onshore refers to a facility's physical location, and history and context make clear that that physical location is a location on land.
Let's just start with the word onshore. This case is a little unusual. Usually parties throw dictionary definitions at us, and each side is saying the text is crystal clear the way we want to read it. Here, there's actually agreement on both sides that the word is ambiguous. Onshore can mean at the coastline, or it can mean anywhere on land, right?
So I would take issue that we think the word is ambiguous simply because it has two plausible dictionary definitions.
Well, just starting with onshore.
Yeah, the dictionaries say what they say, and they set out the universe, I think, of what the commission can use to determine whether something is, what the meaning of onshore is. However, I think everyone agrees at this point, onshore really can't mean near the coast in terms of a distance measurement, because that would result in utterly arbitrary decision-making. A facility, a liquefaction facility, 1 mile from the coast may be in, 2 miles from the coast may be out. The commission does not carve up the world that way. If it regulates facilities hundreds of miles inland.
Put aside your arbitrary and capricious point. And just in terms of what the words can mean, at or near the coastline is a perfectly accepted, coherent meaning of the word onshore.
In the abstract, I think that's right. In the context and history of the Natural Gas Act, I don't think that's right. Historically, Section 3 of the Act gave the commission jurisdiction over facilities as derived from Section 3's regulation of imports and exports, the activities themselves. That's what this court held in district gas. Even if facilities are located entirely in one state, which are normally carved out from the commission's jurisdiction, import or export facilities, they fall within the commission's jurisdiction. That was Border Pipeline from 1949. That was district gas. That was the backdrop on which Congress acted in 2002 when it carved out deep water facilities. And then 3 years later, when it enacted this definition, court, commission officials testified to Congress, this is the way the world is carved up. Deep water facilities are subject to the Department of Transportation's jurisdiction under the Deepwater Port Act, and basically other import or export facilities. At the time, it was import primarily, but they are subject to the commission's jurisdiction historically.
If we move from text to structure and context, right, which we all agree, we do that as part of Chevron step 1. The context is, there are 3 categories of facilities. They're the ones that are in the deep water. They're the ones that are in, I'll just call it the shallow water, the water that's within state jurisdiction. And there are the facilities that are onshore, right? Whatever that means. Doesn't the water-based focus of that scheme suggest that onshore means at the shoreline?
No, I don't.
Say, I might be in deep water, I might be in shallow water, I might be onshore, right? That doesn't mean I might be in Nebraska.
I don't see that connection. I think Congress was primarily concerned with exports and imports by ship.
Mhm.
So, and the words they used in the definition suggest that was its focus. But the commission, for example, doesn't say there's only certain facilities in state waters are subject to its jurisdiction. State waters are state waters. I think the same is true with onshore. I mean, I think to go to your question, it gets back to the arbitrariness of setting a distance measurement from the shoreline. Nebraska's too far, but maybe Louisiana, central Louisiana is close enough. I don't think anyone thinks that's a coherent scheme, regulatory scheme. And that's certainly not, it would be the first time, I think, if what you're saying is suggesting it would, or correct, Congress in 2005 meant for the first time to take facilities used for foreign commerce and natural gas and give them to the states to regulate the ban, to determine whether they get built or how they get built. And that's exactly the opposite purpose Congress had in 2005, which was to preempt the states. In that situation, California was contesting the commission's exclusive jurisdiction. So the words of the statute really talk about the function of the facilities. The words onshore or in-state waters are to make clear that the commission's jurisdiction not extend to deep water ports.
I think one other contextual clue here might be, and just keeping in mind that I think your burden is to show that it unambiguously has your meaning. Again, putting aside the arbitrary and capricious challenge. But in addition to what Judge Katsas points to, the statute also references transported in interstate commerce by waterborne vessel. Isn't that another indication that we're focused on water, the shore? It doesn't say transported in interstate commerce by any means.
Well, traditionally, the commission had jurisdiction over interstate commerce under Section 7. And under Section 7, historically, it has read the different wording of that provision to exclude non-pipeline transport. So what Congress did when it enacted Section 3 was not only strengthen the commission's jurisdiction over imports and exports, for example, by amending Section 1, but also to expand Section 3 to include this sort of interstate component that had historically been, the commission had not historically regulated under Section 7. And once again, Congress may have been concerned with exports by ship, but not whether the facilities themselves were located at this certain shoreline. Most facilities are, because if you're going to export or import by ship, you're going to want to be near the shoreline for cost reasons. But whether the jurisdictional analysis, whether the commission or the states should regulate a particular facility, it doesn't coherently make sense in terms of a distance measurement. In fact, the commission does not adopt a distance measurement at all. It says we won't do that. What we're going to look at is method of delivery of gas to the ship. I think that's a red flag that the commission, cannot come up with a coherent interpretation of onshore. That means near the water, but it has to substitute a whole different test to provide some type of alternative regulatory scheme that it can apply to different various.
How are you asking us to think about this? You're addressing now your challenge to the direct transfer test. Essentially, are you asking us to think about that as essentially an arbitrary and capricious issue, or is it a statutory interpretation issue?
So I think it's more of a statutory interpretation issue. We don't ask the court to determine what we think the facility would be close enough if there were a distance measurement. It's pretty close at 40 miles from the coast. But ultimately, it's the commission that has to decide that. If the court thinks the court disagrees with us that onshore means on land unambiguously. The court should conclude that the commission's interpretation that treats onshore as a method of delivery as opposed to a geographic area is not a plausible one, and then remand so the commission can come up with a distance measurement if it sticks to that interpretation.
In your rehearing petition, really focused on the argument that onshore means anywhere on land. And then you maybe have a fallback. You have a somewhat cursory rhetorical line that if the precedents require a more direct capability of transferring LNG than the quarter-mile process here, they are contrary to the plain language of the statute. That seems, that's a statutory argument. That's not an arbitrary and capricious argument.
I think our focus both in for the commission and here is a statutory one.
Right.
So if, for example, the commission, if the commission,
I think that probably entitles you to make a statutory argument that the direct connection test can't be reconciled with the statute, the onshore as used in the statute, construed in context. I'm not sure it entitles you to make an argument that, assuming that's a permissible statutory construction, the commission didn't adequately explain it.
right, and I don't think we make a lack of reasoned explanation.
You don't think you make the latter.
And, other than
But you're sort of trying to smuggle it in when you say that onshore can't mean on or near the shore because the commission says it would be arbitrary to determine onshoreness by just an absolute amount of distance.
So let me be clear. Our primary argument before the commission here is onshore means on land unambiguously. Right. The commission doesn't have jurisdiction.
Right. I got that.
So if the court disagrees with that and reaches the second argument, we don't think the commission's alternative interpretation of onshore, where it says it means near the coast, but doesn't actually apply a near the coast test, is would satisfy Chevron's second step. Now, the court has said the Chevron second step analysis is similar to an arbitrary and capricious analysis. So in that sense, you can say it's an arbitrary and capricious challenge, but we don't contend that this court should decide that the commission has determined that 0.25, a quarter mile is too close or not close enough. The commission did not engage in that analysis because it substituted geography for a completely different standard that looks to method of delivery. And so that, in that sense, even if the court were to give the commission deference, it really didn't exercise that deference in any sort of way that the statutory text would permit.
Well, why is your primary argument the onshore argument as opposed to the argument about the FERC says that LNG terminals must be capable of transferring LNG onto waterborne vessels? And where's the statutory support for that? I don't understand why this wouldn't be your primary argument when it's so much, I think, stronger to show that this is not consistent with the statutory text structure, context, intent.
Well, we focus on the meaning of onshore as on land because we think that's the better order. We think that clears up a lot of, I think, confusion as to the commission's test. But I do think we make that second argument that
you do. I'm just wondering about the emphasis.
Yes. No, I think it's. I think if the court were not to conclude in this case that onshore means on land, the court may face these questions over and over again. So these could be just moved further back if the commission has to come up with a distance measure.
Do you have a sense of how many facilities we're talking about? Like, is this proliferating? It appears that this is a kind of new technology, at least since 2015. So when the statute was written, this type of facility was not in use. And so it's a novel technology? And how many facilities are we talking about, if you have a sense of order of magnitude, that you're saying FERC should be regulating, but it is not?
So for export or import facilities, I want to say they're in the 20 to 25 range. Maybe the commission would have a better number. And most of those, at least by volume, I shouldn't say most, but in terms of by volume, most of those will be the types of facilities that the commission says it can regulate, which are directly transferring liquefied natural gas to ships.
My question was about the ones that are putting the LNG into containers that are then trucked to the ports.
That's a little harder to determine because the commission has not regulated them. So we only know about them because of these declaratory rulings. There haven't been too many recently. The other thing that makes it difficult, and maybe the commission has statistics, but you can have these facilities that operate domestically, and so they could be located anywhere. So I don't have a precise number.
Thank
you. If my understanding is, if an LNG facility loads liquid gas into the container and then puts it on the truck, right? That's what we're talking about. If the truck then just drives across the border, FERC's position is that the truck is not an export facility. Do you disagree with that?
So I guess we don't disagree or agree because FERC says that, but it has not pointed to a prior commission order that undertakes the analysis. And we haven't been able to find that ourselves. So it's sort of a suggestion that's not backed by anything. Since those do not involve ships, perhaps FERC can explain.
We're figuring out the consequences of your theory, so.
Right, and I don't think those facilities are very numerous, but it's a little hard to argue in the abstract one way or the other to differentiate or not differentiate that situation because I have not seen any analysis by FERC explaining why, whether, for example, those exporters need an export license from the Department of Energy, why those facilities are excluded if they are. So it's a little hard to sort of differentiate that. We have here a definition that Congress enacted, obviously, that we can sink our teeth into and interpret. We don't have anything commission on the truck transport across the board.
I mean, if you accept that the truck driving the natural gas across the border is not an export facility, and FERC says this facility is sort of like that, right? Once the gas is put on the truck, that's the end of the facility. The truck leaves and, it might be destined for a ship. It might be destined for the border. That's kind of downstream from the facility.
Well, I don't think it said that in this order. And if it had, we might have.
Well, it said that in Pivotal.
Pivotal, yes. Well, Pivotal involved a situation where the facility was putting LNG in containers, and then its customers were either going to be domestic customers or people who entities that exported the gas. So so it did say that. I think it mentioned that in Shell. It did not rely on that reasoning here. But once again, neither of those orders cite any prior commission order that talks about truck. So
I guess I'm wondering, it might have something to do with FERC's idea that, pipelines are different. It might have something to do with FERC's idea that dedicated facilities are different.
So those are,
and you're saying, don't worry, our theory won't upset the apple cart too much because those are guardrails in place and we're not challenging them. But I guess I'm wondering if your theory will put all of that in doubt.
Well, I wouldn't say that necessarily. It might. I mean, FERC still has to follow the statute. FERC does. I am aware FERC has a history, as I mentioned earlier, of construing Section 7 because of the particular language that Section 7 uses regarding interstate Commerce in Natural Gas, say that only regulates pipelines. It does not regulate interstate truck delivery of LNG. But that was a longstanding interpretation by Federal Power Commission from 1973. So that was a regulatory backdrop that Congress would not, I don't think, has ever applied to until recently, has ever applied to exports or imports.
Yeah, I didn't go back and read Shell directly, but as we described it in New Fortress, it treated that aspect of Section 7 and that aspect of Section 3 as
and FERC found in this case that this facility does satisfy the pipeline connection requirement. That's why it's not before the court because of that. So to the extent FERC is concerned about pipeline focus, it has an element in its three-part test that looks at that, and this facility satisfies that element. So, but the question then is the second element of this three-part test, which is what geographic area does FERC have jurisdiction over? What geographic area do the states have jurisdiction over? And our position is Congress intended to give FERC federal jurisdiction over facilities regardless of where they're located, except for deep water.
Just briefly, this case has the odd feature that we've been talking about, a facility the company says it doesn't plan to build. And on mootness, one of the main concerns you express in your brief is essentially that if we were to conclude the case is moot, then maybe No Petro would change course and you would then be time barred from challenging these orders again. But we, of course, have the authority, if we believed the case was moot, to vacate those orders. So wouldn't that address whatever lingering concern you have about this facility?
No, we addressed that in our brief. Your court certainly should, if it finds the case moot, to vacate the orders. But FERC's policy at this point is pretty clear. As long as No Petro uses trucks, they are not going to be subject to FERC's action. And so they don't have to go back to get another declaratory ruling.
Right. They'd be running a pretty significant risk that FERC would change course, or that you all would go and file another petition somehow to bring it in front of FERC and secure a review. I mean, that's why they come and get a declaratory order in the first place, right?
I'm sure they wanted the certainty that declaratory ruling provides, but having received the declaratory ruling, FERC setting out its position, the fact that the court has on paper vacated the order does not change FERC's policy. Yeah, I don't know that No Petro would have much risk of a FERC enforcement action, especially given that FERC is saying this is a longstanding policy that we've consistently applied to other facilities. FERC to then change its position to No Petro's detriment on its own, I think, would be very odd for an agency to do.
That's what happened in District Gas.
It does happen. That was a long time ago.
And New Fortress, I believe. Yeah.
Yeah. But in terms of the mootness standard, the courts are pretty watchful that plaintiffs, if or petitioners do receive the relief they ask for, and then if they're going to dismiss the case as moot, that it's really absolutely clear that they won't be harmed by a change in voluntary action later down. I think that all of the cases decided to all stand for that. Okay. Thank you.
Okay, thank you. We'll give you rebuttal.
May it please the court, I'm Matthew Glover and I represent Respondent, the Federal Energy Regulatory Commission. I think I'll start with some of the questions you had for opposing counsel as to the interpretation of onshore.
Why don't you start with mootness? It's jurisdictional.
Yeah.
We asked you for views on whether this case was moot, and you gave us precious little.
Fair. Unfortunately, I think this is one of those circumstances that I learned early in my time in government where sometimes the government isn't taking a firm position on something, and it may be disappointing to the court. But I have a couple points.
We have to deal with it. So what is the commission's position?
So we don't have a definitive position on whether this is moot, but a couple of points in response. First of all, we've said repeatedly that these are case-by-case determinations when we issue these jurisdictional determinations. I think it's footnote 12 at page 43. We made clear to No Petro that this is only as to the project specified here in the declaratory order, sorry. And I think at footnote 33, we also note that, if you had a different facility that was loading LNG pieces onto trucks, but, you were loading it at a dedicated LNG facility, or not on a truck, sorry, containers onto ships, we're not addressing that here. So this is going to be very limited to what No Petro is doing. We weren't clear from their letter. Their interest in kind of the precedential value, I don't think could keep this case not being moot. So it becomes a question of how likely are they to construct this facility, No Petro themselves. I think as petitioners pointed out in their supplemental brief, in cases where we issue a certificate, we had one of those called Jordan Cove. What we did when the petitioner no longer sought to build that facility, we actually asked the court for jurisdiction back because we'd filed the administrative record. And then we asked the parties, shall we vacate the certificate? They said we should. We vacated the certificate. We came back to the court and said, you should dismiss. As they point out, this is not a scenario where we've issued a certificate. We've made a declaratory statement as to this specific facility. And the ongoing policy concern, I don't think they can sustain that. I mean, I looked at Del Monte Fresh, a case from this circuit talking about when you seek a declaratory order challenging an ongoing policy, you need standing to challenge that ongoing policy. All of their standing declarations are about people in Port St. Joe, about this specific facility. So, and I apologize if we had more clarity from No Petro saying.
No, I understand that. You on the case by case, you say at points in your order that these jurisdictional determinations are made on their facts, but that's really not your reasoning. I mean, when the rubber meets the road, what you say is onshore means on or close to the shoreline, and on or close to the shoreline means capable of directly connecting to the tanker. And that's a pretty clear rule of law. And unless you change your mind, it will govern a large swath of future cases. I've said the controversy has to be predictably repeatable. It seems like this one will be when and if they try to construct something.
Understood, Your Honor. I think I would just have 2 points on that. Yes, we've said, and we do believe here we were following our previous precedents. But when we're issuing a declaratory order, it's an informal adjudication as to those parties and those facts. And so I'm not disputing that, in the next case, if No Petro decided to try a different facility or build a different facility, filed a new Section 3 petition, the presumption would be the commission would continue applying the same 3 criteria it's been applying. The commission, obviously, given that our interpretation of the statute is ambiguous, and we've picked the best interpretation, but we haven't stated this as the only interpretation or this is sort of the only required aspect of the statute, we've left ourselves room that a future commission could change its position. In that sense, you're sort of like challenging a court precedent. You're asking for a declaration that precedent is no longer good or that it wouldn't be applied in the next case, except we don't have the LaShawn A versus Berry that you're faced with where you need an en banc court or an Irons footnote to change your precedent. We are an agency. As to the remedy in mootness, I think Northern California Power Agency versus Nuclear Regulatory Commission confronted a situation where a party other than the petitioner, it was a petition for review from the Nuclear Regulatory Commission, a party other than the petitioner caused the case to become moot through a bankruptcy agreement. And the court said, in that case, the normal remedy is vacatur. If you were to vacate these orders, No Petro would be proceeding at their own risk, given that they wouldn't have an order as to this facility. And in terms of the precedential value for any future facility, again, you could take the New Fortress approach. New Fortress did not seek a declaratory order. They started construction on their facility. We issued them a show cause saying, gee, this seems to look like a jurisdictional facility.
Suppose we vacate the order on mootness grounds. Petro changes course. They decide to take their chances and they start building the facility. would public citizen have any means of securing judicial review at that point?
I think they could ask, I should have checked once more this morning because I looked last week at our declaratory order regulation. I think they could ask for a declaratory order to remove uncertainty. That's one of our grounds for a declaratory order. I think if it was the same facility in the same place, they would have the same members. They would have, standing. And
would you have to adjudicate that, or is that discretionary?
It is discretionary for us to adjudicate that. Sometimes we dismiss them. Even when we dismiss them, parties take the rehearing provision in at least in the Federal Power Act is where I'm more familiar with it, but it's interpreted the same as the Natural Gas Act, would allow them to, ask for rehearing of our dismissal. If we said we're not going to address this again, they could ask for rehearing, and then they could come to this court and say, gee, they wouldn't give us a declaratory order. We think that this is, I guess that's, like, in terms of the cases they cite, like Sands and Knox on mootness, a lot of that turned on the specific facts as to ongoing injury or potential for injury. We just weren't sure when NoPetro made their statement. It wasn't a statement that we might want to pursue this facility. It had a lot of, we might want to use other facilities, which we don't think this declaratory order would cover. I'll take a drink in this merits. As the court was explaining with my friend on the other side, on the merits, we think the statute's ambiguous. We think we have the best reading of the statute, but certainly not the only reading of the statute. In terms of onshore, we do think that onshore or in state waters, transported in interstate commerce, and then also the heading of the new provision, section 2, section 11, or 2 subsection 11, being an LNG terminal. As we explained in the order, I think it's at footnote, the rehearing order footnote 31 at JA 66 cites some earlier commission orders. We cited a number of those and others at page 27 of our brief. LNG terminal or a terminal was typically a large port or was used in parlance prior to the 2005 Act. And has been
let me ask you about that history. Your theory is LNG terminal had acquired an almost term of art status. Public citizen has a striking, and I'm just wondering how much of this is anachronistic, because they say that when the intervening statutes were enacted, there was only one export facility, and it was in Alaska, and I assume it's like what you have in mind here. It's a coastal facility that can directly load a specialized tanker.
So I would have to.
So is that accurate as to export? And it's just the U.S. was doing a lot of importing at the time. Where do we get this established practice?
So if I can, I think narrow or kind of clarify, at the time of the statute, there was one LNG terminal or terminal that was a coastal facility in Alaska. There was, I think, imports. There may have also been exports with the coasts, on the border, and we note that we have exercised jurisdiction over the border portion under Section 3 of cross-border pipelines. There was also potentially transfer via trucking or trains. We weren't going to exercise authority over that. I can cite a couple orders that were actually prior to the statute. If you look, and this is about the Bahamas facility at paragraph 39 of the declaratory order, we cite a Calypso or Tractobel Calypso, which was about a facility in the Bahamas. We were going to regulate under Section 3 the portion of this pipeline that crossed what's called the exclusive economic zone of the United States. It's outside state waters, and the exclusive economic zone of the Bahamas. And so there we were regulating under Section 3 that border crossing piece of the pipeline. It was if you go to Shell, they'll actually discuss how there's 2 different Bahamas orders. There was 2 different proposed projects. Neither were ever actually built. But the interesting thing about the Calypso order that we cite there is there's only one mention of LNG terminal in that order. And it's in a footnote talking about how the LNG terminal was going to be in the Bahamas where the ships dock and they unload their LNG. And then it's going to be piped 42 miles to the US. And we're exerting Section 3 jurisdiction over that portion of the pipeline that's crossing the border. So that would be an example of, I think it was obviously an import facility that was crossing the border that we weren't, calling a terminal.
But I mean, portions of pipeline just seems to me like it might be a different thing. So I mean, you have these facilities, you say gosh, everyone, what everyone understood LNG facility to be is this giant thing that's right on the coastline, and it loads directly or unloads directly from ships.
Your Honor, I have to disagree with our position. It was LNG terminal.
Mhm.
Terminal is what described the deep water port. That's why our energy project head's testimony during the hearing that they cite later in the testimony says the requirements of an LNG terminal are, and the first requirement is deep access. We had been regulating after district gas a sort of LNG facilities, and that's what included the cross-border pipelines. Those were facilities. When we talked about LNG terminals, and that's, I guess I didn't make that clarification earlier in my colloquy with you. The one LNG terminal was the terminal in Alaska. There were other import and export facilities that were being regulated. And so, in terms of LNG terminal in Hackenberry, which we cite in our brief, I think at 27, it's cited in the hearing order at note 31. That case involved Section 3 and Section 7 jurisdiction. We distinguished between the part of the project that had LNG ship unloading and was capable of unloading, 210 tankers a year. That was the terminal. The interstate.
We're just talking about LNG terminals as regulated by 3E, not whatever broader category of export facilities there might be under 3A's, district gas penumbra.
Yes.
Right?
Yes.
So we're talking about can one draw an inference from history about what the term LNG terminal covers?
Yes, and we think you can, again, because when we use the term LNG terminal, we were talking about these, facilities at the coast where a ship is coming and directly offloading LNG to or from the ship. Freeport is a case that they relied on regularly, and we cite also in our brief. In Freeport, they described the LNG terminal as the facilities that were receiving the LNG, and the 9.6 mile pipe was actually called the send out pipeline and described in different paragraphs of the order. And we had different, yes, we approved the LNG terminal and the send out pipeline.
This alternative export means of using containers, did it exist at the time? Was it popular?
So I do think that
It may be that the reason why everyone was thinking about facilities on the shore is not that anyone thought, a quarter mile inland is completely different. It's just that was the only existing technology. And it's sort of like a Fourth Amendment applies to wiretaps point. There's a new technology and all right, so it's a little bit inland, so what?
So I do think that, and I believe the commission said in Shell that there were exports that were, cross-border exports. I described some pipeline ones, but, if you were trucking or taking something by train cross-border, we've never considered that within our jurisdiction.
So Judge Katsas' question was, did that even exist when this was
So,
promulgated? I don't think it did.
The Congressional Research Service reports that are cited in I think, footnote 78 or 81 of Shell, but they're also, I think one of them is cited in their brief, do talk about exports to Mexico and Canada. They don't specify how we're exporting to Mexico and Canada in 2004 or 2009. But
do you not know? I would just think as representing FERC, you would know that this is a technology that started in 2015.
So I do believe, I don't believe that the technology in terms of trucking or taking by rail, LNG or by pipeline is a technology that started in 2015. We just don't have a commission order, and I asked sort of the relevant colleagues, have we ever sort of commented on this? And we didn't have one for that. But obviously there was cross-border pipelines and we were regulating things other than LNG terminals prior to 2005 or 2009. And so, we have, I think, again, maybe more footnotes in Shell and more footnotes in Pivotal talking about a facility in Maine that trucks into Canada. But we didn't have a site there. I, again, reached out to people at the commission. That facility never came to us for a declaratory order, so we didn't have an order stating when that facility started trucking things to Mexico. I looked at the Department of Energy because all of their export approvals are available online. I looked at them last night. There were a number of export approvals in the 80s that sort of specify the countries or import. I think it was mostly imports actually, but imports and exports that specified the country you were coming from. There was, I should have printed it out and brought it with me, but coming from Minnesota and back with pipeline transfers and everything. I don't know about whether any of them specified we're going to truck or we're going to use trains to move LNG away. But again, we were referring to terminals as being these open water ports or.
Counsel, can I ask you to focus on the direct transfer test in particular? Because history aside, we now have a statute in 2005 that you agree in your brief is very broad. It says an LNG terminal covers all natural gas facilities that receive, unload, load, store, transport, gasify, and so on. But your test seems to say that something is an LNG terminal if and only if it has a pipe that directly loads or unloads from a tanker. And I'm just really struggling with how to square that with the statutory text.
So I have to point to footnote 33 where we said we have not sort of taken a position on something that would have a pipe coming into the facility. It would then liquefy at the port and put into ISO containers and be a dedicated facility that load those containers onto the ship. Like we said, we weren't confronted with that. In terms of the pipe, you need a pipe coming in.
I'm sorry, can you say that again? Because the text of your order and the rehearing order says over and over, this is not an LNG terminal because it doesn't directly transfer to an LNG tanker.
Yes.
And to me, that seems to be the rule you've applied clearly distinguishes between two exactly identical facilities, except that one has the pipe that goes directly onto the tanker and one has a pipe that loads into containers and they get trucked over, or maybe even there's a crane there and it gets put on. That's the test that you apply.
If I can unpack that a little bit, when we're talking about natural gas facilities, it needs to be a facility dedicated to natural gas. And so in this specific no petro proposed facility, the trucking to a general use port, we even discussed how the crane at the general use port, that's then not part of the facility because those are general use. I was commenting that I think it's in the declaratory order and not the rehearing order. Footnote 33 talks about how we haven't taken a position on a facility that would have a pipeline coming in. It would liquefy right there at the coast. LNG tanker or not an LNG tanker, a ship would come in. It would be, solely, not a general use facility, but solely for the purposes of natural gas. Instead of piping it into the ship, it piped it into a ISO container and craned it onto. We have a footnote saying.
Could you please answer Judge Garcia's question? Because it's also something that I would like to know the answer to. How does your interpretation that requires an LNG terminal to directly transfer LNG onto a ship, how does that square with the statute, the structure, the context, and the intent of Congress?
So directly transferring, all I meant was, we haven't said directly transferring.
Could you please just answer the question?
Okay. Directly transfer comes from the statute's, focus on onshore or in-state waters, and it being an LNG facility. We said historically LNG facilities were facilities that, if I can quote real quick, that were connected via pipeline was one, but the relevant one was located at the point of import or export such that LNG is directly transferred to or from an ocean-going bulk carrier LNG tanker. So, we thought of them being at the point of export or import, and historically the point of export or import was directly transferring onto an LNG tanker. And so that's where we get the direct transfer test. Heretofore, the direct transfer has always been by a pipeline, but we did leave room that
Counsel, I just want to go back just to clarify. The concern is that we're interpreting the words located onshore, right? And it seems to me that here we could have a facility that's located right on the coast. It does maybe 4 or 5 of the statutory, activities, right? It gasifies, it liquefies, it transports, and it's on the shore. And somehow your interpretation of the word located onshore would mean that's not an LNG terminal. And it's based on whether it transfers and how it transfers to a ship. I think that's sort of the fundamental problem I see with the direct transfer test. You have sort of a way to connect this back to the text.
So connecting it back, the direct transfer test is about focused on locating at the point of import or export, which we deem to be the point at which you are transferring the LNG for purposes of bulk carrier facilities onto the vessel, if that makes sense. And so if you imagine, say they couldn't get permitting or something for the Port of St. Joe. No, Petro had said in their application, or if the Port of St. Joe is full, they might truck to Jacksonville, which I think is 200 and something miles, or Mobile, Alabama is 200 miles the other direction. You could have a facility that was located right at a coast, but was not using a nearby port, but was trucking, many, many miles away. Again, we would say the trucking cuts off it being a LNG facility because you're trucking to a general use port. And that facility might be located, it might be located very close to the shore or right at the shoreline, but it's not at the point of import or export because that other general use port is the point of import or export. It would sort of distinguish if you built, thinking about, trucking to Canada, if you built a facility on the sort of coast of Maine, or I guess in the Puget Sound might be easier, in Washington, right up against the water, but then you trucked up into British Columbia, we would say the point of import or export is the truck crossing into British Columbia, and that facility is not located at the point of import or export. And so that's where we're thinking about LNG. Again, the terminal we think does describe deep water LNG ships, but we're thinking about where is the point of import or export. And that's why for pipelines, it's that stretch of the pipeline that crosses the international border.
Let me try it this way. You've just said that if you have a facility loading crates, I forgot the term.
ISO containers.
Containers.
Yeah.
If you have a facility loading containers, it can be right on the border, or it can be anywhere, right? And once the item is loaded on the truck, that's the end of the facility and you're not at the point of import. But let's focus on what you think is regulated. Is there something about the directness of transfer that just bakes in geography? Because I have the same concern my colleagues do on direct transfer, which is just if you think at the highest level of generality, the statute requires geographic proximity, and FERC has replaced that with some concept of directness. And that seems problematic unless there's something, unless, I don't know, technologically, a direct transfer facility has to be right there at the coast.
So I think this goes to that, the direct transfer is what we think of as the point of import or export. And so we've traditionally only regulated, including for the cross-border pipelines, just the point of import and export was was the Section 3 jurisdiction, and the Section 7 jurisdiction was the interstate.
But even the facilities, the Paradigm LNG export facility that you think the statute covers, right, has on the outgoing end, it has like a mini insulated pipeline, right, that affects a transfer from the facility to the specialized ship.
Yes.
Okay. Is there some reason why that insulated pipeline can't be 1/4 mile long?
So if the pipeline is still transferring directly to the ship, I think we would say, because the facility includes that pipeline, the facility is then running up to the point. Sorry.
If it were in Nebraska and the pipeline ran to the ship, that would be onshore?
So it would actually be a little bit different there because the pipeline from Nebraska to whatever the point of export or import state would be a Section 7 pipeline. And so because it'd be interstate, it would be transiting. And so that would then be exempted from Section 3 and put in Section 7 by the Section 211.
Okay, 10 miles away in the same state.
So
Onshore? 10
So
miles inland in the same state. Onshore?
So I think the Freeport example or the Alaska gas line example is sort of thinking in Freeport, the liquefaction facility was right at the shore. The inland pipeline for the intake was 9.6 miles. It was a traditional terminal right there at the shore. I suppose if you did the liquefaction at the other end of the 9.6 and you had the pipe is all going to be still part of the same facility, and the facility is still going to extend to the shore, if that makes sense.
So your answer,
And still going to be directly transferring at the.
so I don't want to put words in your mouth, but I think your answer has to turn on the metaphysics of what the facility is. And if you have, the facility needs to load the ship, you need a pipeline to do that. you're saying that pipeline by definition is part of the facility. And it turns out most of these things are right on shore and the pipeline is 10 feet long, but same analysis if it's a quarter of a mile long.
Again, the facility has to extend to the point of import or export, which in the example you're giving me is the pipe sort of piping into the LNG tanker at the coast.
Yeah, and I guess I'm just trying to figure out, is that pipeline going out from the facility, is it more like a truck, which feels like it's just a different thing, or it's just part of the facility? You've got the storage tank and the pipeline is just an arm coming out of it, and there's something about the science or the technology that just requires you to treat that as one unit.
I think it's partly because it's the same sort of facilities and things that we've traditionally regulated: the port, the coastal, the LNG tanker berth, et cetera, the takeoff pipeline, the liquefaction facilities, the storage facilities. They've all been part of a facility. And again, traditionally, when we've had applications for these and when we've talked about an LNG terminal, again, the terminal language was for these large tankers. We had other cases about pipelines, crossing interstate. The natural gas facilities language in section 211, that's where we draw our sort of first criteria that it needs to be dedicated to natural gas. So again, the pipeline's dedicated to natural gas. It's all part of the same natural gas facilities. They're only dedicated to natural gas. Now, Petro here broke that chain of natural gas facilities when they load these general use containers onto trucks and they truck to a general use port. We did have, I think in paragraph 12 of the declaratory order, and I can't recall the paragraph in the rehearing order, we talked about the crane, even though it's owned by no Petro, still wouldn't be a part of the natural gas facilities because it's a general use crane. So,
Can I ask something? It seems to me that what FERC wants to regulate, correct me if I'm wrong, is safety. And what's happening at these facilities is they're, I guess, cryogenically freezing the natural gas to make it liquid. It has to get to whatever 260 degrees below Fahrenheit, whatever it is. And it seems to me, why does it matter where the facility is? If the purpose of this regulation is to promote safety?
So I think the purpose of the Section 3E addition was to make clear that FERC was going to be regulating the siting, construction, and operation of these facilities as compared to states. There was obviously a dispute between California and FERC going on at the time about a proposed LNG terminal in the Port of Long Beach.
And by all accounts, it seemed that FERC wanted standards that apply everywhere. They didn't want different states doing this on their own, and different states have different capabilities and experience in regulating something like this. And so I'm just trying to understand why it is that FERC doesn't want to regulate these facilities unless they're right on the coastline, because it seems to me it's a matter of function, not location, if your goal is safety.
So I think we've traditionally interpreted Section 3 similar to how we interpret Section 7 and taken the view that you needed to be an importer, like at the point of import.
But why? I guess you keep going to it's our tradition, but I'm trying to understand why?
We understood that the Congress's purpose when it initially drafted the Natural Gas Act to be concerned with the interstate pipeline transport. At the time, we didn't think that exports included the facilities. It was district gas. I think Judge Katsas or Judge Garcia during petitioner's colloquy noted that it was district gas where this court sort of informed us that Section 3A covered more than just the actual import or export of the gas. So, our earlier reading of the statute was that it was focused on pipeline transportation for Section 7. It was focused on the actual import-export sales, rates, terms, things like that. And so I'm not sure that we've treated the statute more broadly, even after district gas, as being focused on safety as much as it's focused on we're the party that regulates, terms and conditions. And in some of these, when they're not asking for a declaratory order for import or export, but they're asking for certain rates if they're importing that they're going to be selling into the market and other things like that.
But you're charged with regulating site and construction, et cetera. That's not rates.
Yes.
It seems to me that, correct me if I'm wrong, doesn't that all go to safety? Like, why else would you have to regulate site and construction and how these things are run?
I think safety would be one concern, environmental interests, regional interests. We've traditionally similarly regulated kind of siting of pipelines in the Section 7
So my question is, why does that depend on where it is, whether it's a quarter of a mile from the shore or 5 feet from the shore? Why does it matter?
For us, it matters for two reasons. We think that the statute used onshore and LNG terminal to talk about these deep water, or not, I shouldn't say, to talk about these sort of bulk tanker facilities. And we traditionally treated our export and import jurisdiction, even after district gas, as focused on the point of export or import, which was that kind of point of crossing a border or point of crossing an economic exclusionary zone.
Let me try it this way. It seems like the practical effect of what you're doing is to draw a regulatory distinction between facilities that are loading specialized tankers through an outgoing pipe and facilities that are loading cartons for shipping. What is the difference? Why might someone want to treat those two categories differently?
So the general use containers or general use cargo ships, I think is what you're asking me. You know, we've always viewed general use facilities as outside of our jurisdiction because natural gas facilities meant things that were specifically dedicated to the import and export. And so that's where the import and the point, and so we need the point of import and export to have dedicated natural gas facilities. And so that's where the pipe that loads onto an LNG tanker ship is the point of import or export.
All it's doing is natural gas.
So, sorry?
All it's doing is natural gas. The truck that carries these cartons, can it just be any old truck and all the technology is in the carton doing the insulating, or do you need a special kind of truck
I assume
to
that,
carry LNG?
well, so for purposes of this project, they're carrying LNG in these ISO, International Container
Containers,
Organization.
right.
Those containers can carry other things. A colleague said like orange juice is something that they often want to cool when they're trucking that they would carry in
The
those containers.
trucks, the trucks could carry.
Yes. So if you cleaned it out after you had natural gas, you could have something different in that container. To your specific question, I assume that there's some sort of ISO container carrying truck, so it might be different than a general flatbed, but it's going to be some sort of ISO container truck.
Either the truck or the container can accommodate.
Natural gas or
Something.
orange juice or something else that needs to be kept cool and is in a liquid state there. So yeah, yes, I guess so we don't view those trucks as dedicated natural gas facilities. And so that kind of breaks the chain of what is the facility we're talking about with respect to no petro.
I mean, that might be an argument for why direct connection flows from your dedication requirement. But you linked it to onshore, which is the geographic requirement.
Yeah, I think, again, I think our three criteria come from natural gas facilities located onshore in state waters, transported sort of the waterborne aspect of the onshore there. And also from our use of LNG terminal, which again is traditionally these bulk carrier facilities are what we called terminals. In the congressional testimony, we described you needing ability for these large tanker berths. The point of import or export is, you know, we demarcate that and we didn't decide to have some sort of geographical proximity to the point of import or export. We looked at our traditional practice. We looked at what we'd seen before and thought the point of import or export is where you're directly transferring something to the foreign country in the case of a pipeline or to the tanker in the case of these LNG terminals that we had seen.
It seems to me that you're relying a lot on your traditional practice or what you've always thought, but we have a statute here that is really inconsistent with your traditional practice, and the statute has to control, right?
Yeah, I'm not sure that, or I guess we don't think the statute's inconsistent.
Well, where in the statute does it say it's deep ports? It says all natural gas facilities that do all these things, transport, gasify, liquefy, process. And where does it say at the point of import or export? It says that is imported. It doesn't say at the point of import or export. None of that is, the way you've construed the statute is at odds with what the statutory language says.
I think we think that natural gas facilities that do these functions for gas imported into the United States or exported from, again, you're right. We're construing it against our traditional understanding of what Section 3 is doing.
Correct.
And we don't think
I'm
Congress.
suggesting to you that your traditional understanding, to the extent it conflicts with the statute has to control. And I'm asking you to point out where in the statute it says that it has to be next to the water, and it has to be one of these deep port, big natural gas terminal things that you're thinking of? And where does it say that it has to be at the point of export?
So obviously, we think that the statute's ambiguous and it's broad, and we think that Congress was legislating against.
Where's the ambiguity?
Onshore, again, as meaning at the shore, it can also mean coming towards the shore, like an onshore wind is a wind coming from the ocean to the shore. It can mean located on land. So we think that onshore is broad and ambiguous. We do think that in using the term LNG terminal in the legislative history, talking about these coastal facilities and LNG tankers, Congress was, intending to legislate against our regulatory backdrop. And so we think that the broad ambiguous language of the statute was not meant to displace our traditional understanding, to legislate in light of our traditional understanding. Again, they used LNG terminal, which was a term we had used in prior orders describing these coastal facilities that had large tankers. They didn't use, all export facilities.
The different definition of LNG terminal than your traditional understanding. And it doesn't say at the point of import or export. Where is that ambiguous?
No, it didn't. I think, and I believe this is covered in Shell or in Pivotal, but we had traditionally thought of the point of import or export versus the interstate commerce as being the line between Section 3
We're
and
back
Section.
to tradition, and I'm looking at statutory.
Well, I was going to point to, in Section 211B, they excluded any pipeline or storage facilities subject to our Section 7 jurisdiction. And so we thought that was an indication that, again, for these cross-border pipelines, they were still thinking about the distinction that we have traditionally drawn between Section 7 jurisdiction and Section 3 jurisdiction. That was an issue in other cases about intrastate transit or about where the Section 7 regulations came versus Section 3. But we did think when they exempted the Section 7, they were sort of thinking of our traditional line between Section 3 and Section 7. Thank you.
Thank you.
May it please the court. I am Jennifer Key. I am representing the intervener, No Petro LNG LLC. And I'm here just appearing to reinforce the position that my client does not view the case as moot.
What can you tell us about your client's intentions?
I could tell that they do not have plans to move forward with this project at this time. And that's due to market conditions, as we stated in our letter. That doesn't mean we've abandoned the idea completely at this port or any other port that has a suitable facility, a suitable area nearby where we might engage in this activity.
For how long does the declaratory order protect you if you want to begin construction?
I mean, I view it protects us till another commission comes and changes the policy. So for indefinitely.
Indefinitely. You would build the plant if the price of natural gas goes up.
Yeah, and we need to find the right off taker, and definitely the price of natural gas, I think, has an impact here. But we definitely think the standard generally used of the issue arising again has to be, too remote and too speculative to not occur again. We don't think that standard of too remote or too speculative has been met. And the other often used speculative, that it's absolutely clear that the behavior which...
As to your client's intentions, I imagine what you just said probably describes any number of potential projects they might have in the pipeline, right? We've got our list of 20 projects we might do someday, maybe, and this project is now back in that bucket if, the price of natural gas goes up and other conditions are favorable. Is that essentially what you're telling us?
I don't think I'd say it's more than just the price of gas. I think there's other market concerns other than the price of gas, but that basically the reason they're looking to export And particularly, I can tell you this much, the areas they were looking to export to were generally not too far from Miami, the Yucatan, Belize, those areas where they do have trouble with, to produce electricity, natural gas can be used such that, there are entities down there that if the right, if the right project was built in one of those areas that needed natural gas, that they would be interested in. Specifically relating to the port at St. Joe, there is the piece of land that the project was going to go on is contaminated, and it's highly contaminated, such that it should be available to our client because there's almost nothing else that could go there. It would be so when we talk about if a customer came along for the product, that we fully expect that we could. We don't currently have I think an option to lease that piece of land, but that piece of land can basically be used for very few other things.
Thank you. Appreciate your openness. Rebuttal?
Yeah, I would like to make a couple of points about mootness and then a few points on the merits. First, the commission says it decides these things on a case-by-case basis. I think Judge Katsas, as you pointed out, it really has, it doesn't apply a facts and circumstances test. It has a pretty definitive ruling about truck transport being outside of its jurisdiction. It also mentions, the commission mentions that public citizen could seek a declaratory ruling if Petro decides to start up this project again. To my knowledge, there's no timing requirement on a declaratory ruling. The commission could sit on it and Petro could build its plant, and by then the case would be moot. On the merits, the commission spent a lot of time on the term LNG terminal and its historical understanding. It is not a term of art. It's a defined term in the statute. The question is, what does that definition mean? And I think almost nothing in the commission's order really parses out the word LNG terminal. It's about what the meaning of onshore is. The other point I would like to make on LNG terminal, although the commission mentions large facilities that directly transfer LNG onto tankers, the New Fortress decision that this court decided last year involved a completely different type of facility. There was a chain of transfers onto the dock, onto a floating storage unit that then used a small hose to transfer the LNG on shore, and the commission said, we're not going to let you circumvent our jurisdiction through innovative designs. So I think that's completely inconsistent with commission's position that it looks to its historical understanding of what LNG terminals look like. In terms of the statutory definition, I'll just point out liquefaction facilities, regasification facilities, they'll never be located at the point of export because they have to be connected to the ship in some way, either pipe or truck. It's the pipe or truck that will be located at that point of export. And finally, as to the commission's emphasis on point of export, that's not a permissible dictionary definition of the term. The plausible universe of interpretations are on land or near the coast, not near the point of export. I think that cabins the commission's authority altogether. Or has no further questions.
Thank you. Thanks to all counsel. The case is submitted.
Case number 21-5268. Michelle Donahue, appellant, versus United States Department of Homeland Security, FEMA. Ms. Detling for the appellant, Mr. Dryer for the appellee.
Ms. Detling, good morning.
Good morning, Your Honor.
Whenever you're ready.
Thank you. May it please the court. My name is Rosemary Detling. I'm representing the appellant, Michelle Donahue. The primary issue in this case is whether the trial court allowed defendant to circumvent its obligations under Rule 26. As we all know, Rule 26 requires litigants to provide disclosures early on in the litigation to enable them to conduct discovery in an efficient manner. Rule 26E also requires litigants to supplement discovery and disclosures so that they are prepared for trial. In this case, the events in question occurred in 2010. The appellant filed an EEO complaint, an informal EEO complaint, and the agency investigated her complaint in 2012. She filed a federal complaint in 2016. She provided initial disclosures in 2018, and the defendant also provided initial disclosures in February of 2018. It wasn't until June 17, 2021, when defendant disclosed 15 previously non-disclosed witnesses. There's no doubt, there's no dispute in this case that defendant did not abide by Rule 26's disclosure obligations, and defendant does not allege that they did abide by that. Their sole argument is that they had no duty to disclose the names of the witnesses because the witnesses were made known to the appellant. The argument they made to the trial court after we filed a motion to eliminate was the same. And at trial, the parties argued the motion to eliminate. The defendant again argued to the trial court that the witnesses' names were made known to the appellant, and the defendant provided hundreds of pages of discovery as proof. The trial court agreed with defendant that the witnesses were made known, and the trial court approved 9 witnesses to testify. 4 witnesses ended up testifying. We contend that the trial court's decision was an abuse of discretion because the witnesses' names and subject matter was never made known to the appellant. The trial court overlooked the fact that that Rule 26 specifically states that the subject matter must be made known. And that's the crux of the case, is that the subject matter of these witnesses' testimony was never made known to the appellant. And we believe that the case Ollier v. Sweetwater should be persuasive. The facts in that case are almost identical in this case. In that case, they tried to get in 38 witnesses who were not previously disclosed, and the court held that it's not the opposing party's obligation to go through discovery and assume or guess which name or which witness is going to testify. It's the disclosing party's obligation to provide the subject matter. We believe the trial court erred in not granting sanctions, the sanction of exclusion under Rule 37, because the defendant did not justify its reasons for not disclosing the names of the 17 witnesses. In this
counsel, we were reviewing for abuse of discretion here. Are you suggesting that Judge Maida had to exclude these witnesses?
Well, the rule does say that it's mandatory and automatic, but there are exceptions. So they did have the opportunity to prove to Judge Maida that the non-disclosure was justifiable and harmless. And our argument is that they did not meet that burden.
These witnesses were known to your client, though. They were all people who worked with her, or in the case of Fishburne, was very much at the heart of the case. And then I guess Dodwell worked with her. Holberg was on an email that your client admitted into evidence. Are you really saying that your client didn't know who these people were and what they were going to say?
Yes, absolutely, Your Honor. Fishburne was a contract employee who worked in a completely different area, a different office. She did not work directly with him. He did not report to her. He had a separate chain of command. He reported to a private contract company. She had no involvement with him. And he was, the only involvement he had in this case is he was accused of harassing another female employee. That's why his name came up in discovery. But there's no indication in the record that he had any opinion about the appellant's performance or conduct. And nothing in the record shows that he had any decision-making or that he was consulted in any of the employment actions in this case. So yes, we were completely surprised. And with respect to Dodwell, his name was mentioned in discovery, but only in respect to, his name was actually mentioned by the appellant as a similarly situated comparator in her sex discrimination case. She repeatedly said that he was a similarly situated supervisor who was treated more favorably than she. And the deciding official or the main named responsible management official, Dr. Holterman, was asked in his deposition, was Mr. Dodwell treated more favorably? So yes, he was brought up in that deposition too, but he was never disclosed as anyone who was consulted with or anyone who had any decision-making authority, or he was never disclosed as someone who had an opinion about the appellant's performance or conduct or her behavior or the appropriateness of her actions. And so, yes, there were hundreds of names mentioned in discovery, but to assume that every single person could have something negative to say about her performance or conduct is an onerous burden that the Alder Court specifically addresses. It puts the burden of Rule 26 on the other party rather than the party who's supposed to make the disclosure. And that's fundamentally unfair. With respect to witness Curtin, she was only copied on an email that pertained to class size. So yes, my client had absolutely no idea that she had any knowledge of the fiscal.
Isn't it true that you withdrew your objection to Curtin's testimony?
No, we did not withdraw our objection to Curtin's testimony. Absolutely not. I'll qualify that, Your Honor. We said in trying to be cooperative with the court, we said, okay, we will agree that she can be asked this one question. Were you the one who delivered the message to Mr. Fishburne that he is being taken off the contract? We agreed to that one thing. But then right after that, we did say again to the judge, we vehemently disagree or object to her testifying about anything that has to do with the appellant during that time period. And when she got up to testify, she testified about substantive matters, about how the appellant was to blame for Mr. Fishburne being taken off the contract, and that she went outside of her job responsibilities in doing so. And those were all substantive issues that went to the defendant's case in chief. With respect to Hoberg, she was the trial judge properly excluded her as a case in chief witness, and that decision has not been appealed. But what happened, she was approved as a rebuttal witness, but she didn't testify about the narrow slice of rebuttal that she was approved to testify about. Instead, she testified in the defendant's case in chief, and we objected, but the trial court allowed her to continue and testify about substantive matters. With respect to the justification of it all, if you look at the timeline alone, initial disclosures were due, as I said, in February of 2018. The defendant, and then discovery occurred in 2019. During discovery, we asked specific questions and interrogatories that name each and every reason. We deposed the 4 people they did disclose. We asked them to name the specific names of the people they consulted with. And none of these 17 witnesses were divulged as being consulted with. So they should not have been able to testify to the jury that they had an opinion about why the appellant should have been disciplined. We filed a motion in limine in 2020, and the defendant didn't respond in 2021. It wasn't until 13 days before trial that they dumped the names of 17 witnesses, and they didn't even give us the contact information, even though I emailed and asked for that contact information. So doing that 13 days before trial was clearly intentional and clearly was meant to ambush us. And they have not argued that there was a mistake or it was inadvertent. It was clearly an intentional litigation tactic. It was gamemanship. And to say it wasn't harmless is ridiculous, because these witnesses they corroborated every single thing that deciding officials said. They said, yes, it was the appellant's fault. And in a discrimination case like this, where motive and intent is really important, that really was, their testimony was critical, because our main argument was that all of these bad things happened to her, these adverse actions, because that she engaged in EEO activity. The defendant's argument was all of these bad things happened to her because she had performance and conduct problems. So to have these 4 witnesses come before the jury and surprise us and tell the jury that, yes, she did have performance and conduct issues, and that's why these things happened. I mean, that was not a fair trial. And the appellant waited.
You want to wrap up? You're a little over.
Yeah.
Give you a couple of sentences if you want.
No, I'm done here.
Okay, thanks. We'll give you rebuttal time. Mr. Dreyer.
Good morning. May it please the court. Douglas Dreyer on behalf of the Department of Homeland Security. None of the issues my friend raises warrants disturbing the verdict of the jury here. I'm happy to field any questions the court may have. We request that the court. Thank you.
Perhaps your easiest oral argument ever.
Thank you, Your Honor.
Nice. Ms. Detling, there's really nothing for you to rebut. We will take the case under advisement.
Okay, thank you, Your Honors.